automatically released into the United States. That is not a border. That does not allow for any actual determination of an asylum claim or any legitimate claim under law. Importantly, these releases include hundreds, thousands of criminals that have wreaked havoc on our communities. In 2022, 20-year-old Kayla Hamilton was raped and murdered in her home in Maryland by an MS-13 gang member released by this administration. We have examples like that in every state in the union, and we have hundreds of examples like that in Texas of criminal activity, of people being released by this administration. Even those with ties to extremist groups and activities have entered the country through our border. This includes a migrant wanted in Senegal for terrorism-related crimes. Last March, a member of the terrorist group Al-Shabaab crossed the southern border, was released, traveled to Minnesota, where he was eventually arrested by ICE. Again, there are many of these examples. Indeed, since the beginning of fiscal year 2021, 331 known or suspected terrorists have been caught crossing the southern border. Now, I know my colleagues on the other side of the aisle, some witnesses will pull that apart about, well, what lists do you have that are associated with terrorists? Is it a real terrorist list? Well, is it FARC, but it's not a certain part of the world? The fact is, there is an increasing number of known individuals affiliated with dangerous groups across this world that are flooding into the United States because this administration refuses to carry out its constitutional duty to maintain operational control of the border on behalf of the United States. By the way, that 331 compares to just 11 from 2017 to 2020 under the administration of President Trump. And with the 1.8 million known gotaways, we have no idea how many terrorists and criminals have escaped undetected, because these are the individuals that are actually not seeking Border Patrol. They're not coming across the river and saying, please, hi, Border Patrol, I'm here. Can you take me in, send me over to an NGO, and release me into the United States, which is what we're doing to the vast majority of the numbers. But some 50,000 a month are coming in, and we don't know who they are. But we know that there's some dangerous individuals because we know that they flee Border Patrol. The flow of illegal immigration has also levied unbearable costs on American communities, particularly in Texas. American students have been kicked out of their schools so the buildings can be used to house illegal aliens. The healthcare system is burdened by unpaid medical bills for services provided to illegal aliens. Texas has been forced to spend at least $12.5 billion of its own funds to try to fill the void. This invasion of our southern border is a clear and present danger to the citizens of this country, and particularly to the people that I represent in Texas, as do my colleagues from Texas. A record number of Texans and Americans are dying from cartel and Chinese-driven fentanyl pouring across our southern border. Now, I've seen and read the articles by my colleagues on the left, academics on the left, who say, well, that's just fentanyl. It comes through the ports of entry. Nothing you can do can stop that. It has nothing to do with the fact that we have wide open borders, despite the fact that the experts on the borders, the Border Patrol folks who have to actually do the job, who are pulled off the line to process people in direct contravention of our laws, they will tell you that this is much worse because they're unable to police the borders. They're unable to do their job between the ports of entry or at the ports of entry at the level that they should be able to do so. As a result, 6 children in the school district in which my family resides, just southwest of Austin in Hays County, Texas, died from fentanyl poisoning last year alone. We've had witnesses testify here. We had the mother and the father of one of those kids testify here. We just ignore it. We ignore this grim reality of what's happening to our country. Since 2021, over 5,000 people have died of fentanyl poisonings in Texas alone, but Texas has actually been on the low end historically, but it's going up. Most of the traffic went through Texas to other parts of the country, but now it's sticking. More than 75,000 Americans have died of fentanyl-related poisonings in 2022 alone. We're still waiting for the 2023 data. Over 200 a day. It's basically an airplane full of human beings that are American citizens or people that live in this country who have died from fentanyl-related poisonings every day. I met last week in Bracketville, Texas, about 3 hours from my house, about 45 miles from Eagle Pass, with about 200 landowners and local officials in South Texas, breaking down in tears at the destruction of their community. One rancher who's had to fix his fence 400 times He's had to repair his fence 400 times in the last 3 years. A ranch he's had in his family, losing livestock. Now, people dismiss that as if it's no big deal, but it is a really big deal to the families and the ranchers who have ranched South Texas for years. Talk to residents who live near the border, have high-speed car chases that are commonplace, that result in the death of American citizens recently and migrants. We act like this is compassionate, that 1,000 migrants died along the southwest border of the United States last year. Almost 1,000. And this flow of illegal immigration has enriched and emboldened the cartels. John Mudlin, the chief border patrol agent in the Tucson sector, has told Congress that, quote, nobody crosses without paying the cartels. So the cartels determine when people cross, how many people cross at the time, all of that. It's controlled by them. Now, we all know that. We've seen numerous embed reporters who start in South America, come up through the Darien Gap, go through the entire process that the United Nations is fueling, China is helping fund, cartels are getting enriched by, moving human beings for profit into the United States through a dangerous journey where individuals die along that journey, little girls get sold into the sex trafficking trade. All of that happens, and it's purposeful to flood the United States so that people like our colleague, Yvette Clarke from New York, can say, quote, I need more people in my district just for redistricting purposes, end quote. In the context of a conversation about saying there's no more room in the inn for people to come to the United States. That was the direct quote. This is very clearly an invasion. It is a purposeful one, and it's inflicting dangerous consequences on our country and the people of Texas. We're here to talk about the constitutional powers for states to be able to manage that process in the absence of any effort by the federal government. The Constitution contemplates that states could repel and defend themselves against invasion because they expected the federal government to do its job. In almost a throwaway clause at the end of Article 1, but a clause nonetheless, it says the governors, the people of the state, have the right to defend themselves. It says, quote, no state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war, unless actually invaded or in such imminent danger as will not admit delay. Now, why would this be? Could it be because, as Thomas Jefferson put it, self-preservation is paramount to all law? The fact of the matter is, of course, the people of Texas have a right to defend themselves, just as I have a right to defend my home and my family if it is under attack. I don't go check the statute book. I don't go open the Constitution to determine what I do in the face of a danger posed to the people in my home, my family, as a citizen who derives his rights and the rights for my family from God, not from the government. We have the right to defend ourselves. It is inherent. The Constitution reflects that, and it reflects the fact that governors and states should step in if the federal government refuses to do its job. I look forward to hearing the comments from our witnesses and get their perspectives on these topics. And with that, I will now recognize the ranking member, the gentlelady from Pennsylvania, Ms. Scanlon, for her opening statement.
Thank you, Mr. Chairman. From a constitutional perspective, which is, after all, the purview of this subcommittee, the answer to the question posed by today's hearing, the extent to which states can act independently of the federal government with respect to immigration matters, including border enforcement, has been well-settled law for over 150 years. The Supreme Court has been unequivocal that the Constitution does not allow states to reject federal policy and set up their own immigration regimes, and that when a state purports to stand in the federal government's shoes and take over federal immigration enforcement, it unlawfully violates the principle that the removal process is entrusted to the discretion of the federal government. So why is this hearing happening today? To try to breathe life into a crackpot legal theory that is so extreme that even hardcore conservative scholars have rejected it, declaring correctly that this is an attempt to subvert our constitutional order for political purposes. Federal supremacy over immigration rests on several constitutional bases. These include the federal government's inherent power over the conduct of U.S. relations with foreign countries, including with respect to matters of national security, and its power to establish a uniform rule of naturalization as provided for in Article 1, Section 8. Federal law governing immigration is the supreme law of the land, and state laws may not undermine the comprehensive and complex federal regulatory framework governing immigration. We cannot have 50 different sets of immigration laws, each of them potentially having different foreign relations and national security implications. Such a system would be chaotic. It would leave the country vulnerable, and it would make Americans less safe. That is why the Constitution's framers entrusted those matters to the national government to the exclusion of the states. Attempts by the states to enact and implement their own immigration enforcement policies that conflict with federal law are clearly unconstitutional. In pressing the extreme and unconstitutional legal theories that the House majority and its witnesses are making today, they're attempting to put the rabbit in the hat, even as they're blocking bipartisan legislation to address border security and funding. They're arguing that the federal government's failure to have a stronger border security gives states a license to enact their own immigration policies. So this is a fallacy. Our Constitution doesn't say the states are free to ignore the Constitution and Supreme Court precedent unless the House Freedom Caucus gets its way. It is Congress's responsibility to enact immigration legislation and the funding necessary to implement it. Enacting such legislation requires compromise, bipartisanship, and actually voting on measures which can be signed into law. But the House majority is not interested in meeting that responsibility and has blocked the president's request for supplemental border funding and is now refusing to even consider a bipartisan border security bill that has been hammered out by Senate Democrats and Republicans with the administration. And they've done so at the urging of the disgraced former president who wants to campaign on lies about border security. As we will see, the fringe legal fantasy being pushed in this hearing and by some state officials hinges on a tortured reading of the Constitution that defies both constitutional history and legal precedent. They're promoting the idea that the states have the power to take matters into their own hands because they're being invaded, and they claim that that meets the language of Article 1, Section 10, Clause 3 of the Constitution. Our founders and credible legal scholars are clear that the Invasion Clause refers to protection against armed hostility from a nation-state or organized political entity, not people fleeing danger in their home country and seeking protection under international and U.S. asylum laws, and not even from those engaging in criminal activity. And we should be clear that the courts have considered the volume of immigrants coming to our border when repeatedly reaffirming that this migration crisis does not equal an invasion. I cannot decide which is more disturbing, the torturous attempt to evade the clear constitutional order or the racist dog whistles and inflammatory and demagogic rhetoric being used to justify this invasion argument. We also need to be mindful of the damage done to our constitutional order when advocates for this extremist position are really saying that states are not bound by federal law or Supreme Court decisions with which they disagree. It is disturbing when the chair of the House Judiciary Committee on the Constitution posts on social media that Texas should ignore the Supreme Court's decision last week after the court held the federal government could remove razor wire that Texas had unlawfully placed at the border. The truth is that Republicans in the House, some state officials, and the national leader of the Republican Party want to block bipartisan action on immigration reform so that they can campaign on the issue. They want to grandstand in camo at the Rio Grande and impeach officials so they can campaign on bluster and boogeymen rather than doing the hard work of actually solving problems. That's why today's hearing is yet another irresponsible and potentially dangerous exercise in taxpayer-funded political theater. We need to enact legislation to address border issues rather than just have campaign talking points. And with that, I would seek unanimous consent to introduce the Supreme Court's opinion in Arizona versus United States, 132 Supreme Court 2492 from 2012.
Without objection.
And a Washington Post article published yesterday, January 29th, 24, entitled "Republicans Now Say It Might Be Okay to Ignore the Supreme Court."
Definitely without objection.
Thank you. I yield back.
With that, I do not believe the chairman is here. I will recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, and congratulations on assuming the chairmanship of this subcommittee. I served as chairman and ranking member of the subcommittee for 13 years, and it holds a special place in my heart. Unfortunately, today's hearing is not an auspicious start. It is based on a crackpot legal theory that would have the public believe that federal supremacy over immigration and foreign relations is an open question. There is no open legal question regarding the state's subordinate role in immigration, foreign policy, or border security. The Constitution is clear. The federal government is supreme in these matters. And it is well-settled law that the Constitution gives the federal government primary authority over immigration matters. As Justice Kennedy, a Reagan appointee, wrote, quote, "The government of the United States has broad, undoubted power over the subject of immigration," close quote. The Constitution explicitly provides Congress with the power to establish a uniform law of naturalization and tasks the federal government with conducting foreign commerce and foreign relations, which the Supreme Court has repeatedly noted are interlinked. As the Court has observed, the treatment of foreign nationals within the United States can impact foreign diplomacy and trade, including the treatment of Americans abroad. There is good reason, then, why the framers assigned these responsibilities to the national government. On matters of immigration and foreign policy, the nation must speak with one voice. We cannot have 50 different immigration or foreign policies. Otherwise, there would be chaos at home and danger to Americans abroad. The Supremacy Clause further ensures that the Constitution and duly enacted federal laws are the supreme law of the land, trumping any state laws to the contrary. Despite the Supreme Court's crystal clear reasoning to the contrary, we will hear from the majority's witnesses today that the states retain the sovereign power to exclude foreign nationals. That contention was part of the doctrine of John C. Calhoun of nullification. I thought Andrew Jackson and the Civil War settled this definitively and put this notion to rest. Nonetheless, on this basis, the majority and its extreme MAGA Republican allies make the preposterous argument that the states can ignore the federal government and the Supreme Court because the Constitution permits states to defend themselves from imminent invasion when the federal government has failed to act. There are so many practical and legal problems with this outrageous and absurd theory that I do not know even where to begin. Any logical, or dare I say originalist, interpretation of the framers' use of the word invasion in the Constitution makes it clear that the word invasion refers to an imminent attack by foreign armed forces. Multiple federal courts presented with this question have concluded there is, in the words of the Third Circuit, quote, "no support for a reading of the term invasion to mean anything other than a military invasion," close quote. It clearly does not mean the so-called invasion that MAGA Republicans scream about day and night in their extreme right-wing media echo chamber. That invasion rhetoric is often a dog whistle for the Great Replacement theory, a racist and anti-Semitic trope that suggests that a liberal cabal is directing non-white populations to, quote, invade Western countries to replace their, quote, native white populations. After all, who can forget the neo-Nazis and white nationalists chanting, "Jews will not replace us," in Charlottesville? I trust, however, that the American public knows the difference between armed soldiers crossing the border and mothers with their children fleeing violence in the hopes of claiming asylum, as is permitted under federal law. There is, then, no constitutional basis for this MAGA Republican argument that Texas or any other state can ignore federal law at the southern border. If there is no real constitutional controversy, why are we here today? The real purpose of today's hearing is to serve as one more distraction from the MAGA Republican majority's total failure on border policy. In their desperation to avoid blame for their utter inability to govern, MAGA Republicans instead seek to justify unconstitutional state action by blaming the Biden administration and threatening to impeach Secretary Mayorkas. But if they are looking for someone to blame, they should be pointing a finger at themselves. The Constitution vests Congress with the authority to address immigration and border security policy. Yet instead of doing the hard work of negotiating a bipartisan approach to immigration and border security, as is being done in the Senate, the Republican majority is holding hearings like this one. And they are taking their marching orders from former President Trump, who within the past few days has publicly called on House Republicans to sink a border security deal before most members have even seen the text, no matter what it says, all so that he has an issue to run on in November. I must also note that I was deeply disappointed to see the chairman's public call for Texas to ignore the Supreme Court's order allowing the federal government to remove razor wire that Texas placed on the border. Such remarks, from the chair of the Constitution Subcommittee no less, are highly irresponsible, dangerous to our democracy, and sadly typical of the extreme MAGA Republicans this Congress. This hearing is nothing but a shameful exercise in political theater. But I appreciate the witnesses for appearing, and I look forward to their testimony. I yield back.
I thank the ranking member, for his kind acknowledgement of my assuming the gavel of the Constitution Subcommittee, and obviously his work prior to that. I would simply note that the New York City mayor said, quote, "The migrant crisis will destroy New York City." So it sounds pretty dangerous to me when we're talking about the current dangers this country are facing. Without objection, all other opening statements will be included in the record, and we'll now introduce today's witnesses. The Honorable Mark Brnovich. Mr. Brnovich is a partner at Boies, Schiller, Flexner, LLP, and the former Attorney General of Arizona. Prior to serving as Attorney General, he served as an Assistant Attorney General in Arizona as an Assistant United States Attorney. Mr. Christopher Hayek. Mr. Hayek is the Director of Litigation at the Immigration Reform Law Institute and is responsible for overseeing ILRI's public interest litigation. ILRI is a nonprofit legal organization that advocates and litigates for responsible immigration policies. Mr. Brent Webster. Mr. Webster is the First Assistant Attorney General of Texas. Point of personal privilege, a position that I once held, so I know the job well. Prior to joining the Attorney General's office, Webster served as a criminal prosecutor in Texas for 10 years and served as the First Assistant District Attorney in Williamson County, Texas. He has also served as a civil litigator and criminal defense attorney in private practice. Mr. Omar Jadwat. Mr. Jadwat is the Director of Immigrants' Rights Project at the American Civil Liberties Union. He has litigated a number of cases involving immigration law while at the ACLU. He first joined the ACLU as a Skadden Fellow in 2002. And we will begin by swearing you all in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you. Please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask you to summarize your testimony in 5 minutes. Mr. Brnovich, you may begin.
Mr. Chair, Madam Chairwoman, thank you very much for having me today. Once again, the views expressed today are my own, and I'm here today as a former two-time elected state attorney general, as well as a former federal prosecutor and state gang prosecutor. I am proud to have served our country in the United States military as an Army Judge Advocate General, as well as being a first-generation American. I understand the American dream in this issue better than most. Our nation is founded upon the rule of law, and as I sit here today, not only as a former federal prosecutor and a state gang prosecutor, but a husband and as a parent, I worry our nation is under assault from cartels and gangs that have seized control of our southern border. We have seen an unprecedented amount of lawlessness, human smuggling, sex trafficking, and illegal drugs flooding into this country. And I do believe, and we've written a formal legal opinion stating that this is an invasion pursuant to the United States Constitution. The State Self-Defense Clause in Article 1, Section 10 provides that a state may defend itself when it has been actually invaded or in such imminent danger as will not admit delay. And the state does not need the consent of Congress to do so. The Invasion Clause in Article 4, Section 4 provides that the United States shall protect each state against invasion. This clause provides dual protection against an invasion broadly defined. And this includes not only defending against actions by foreign hostilities, but also other enterprises and more powerful neighbors, as the Constitution states. This encompasses a broad self-defense against non-hostile actors such as cartels and gangs operating at our southern border. Furthermore, the Import-Export Clause in Article 1, Section 10 also recognizes that states retain sovereign authority to execute inspection laws, which requires operational control of the state's border to channel entry of goods to authorized ports of entry. This is an aspect of the historical police power that is expressly reserved for the states. In sum, both the power of self-defense against actually being invaded and the power to execute inspection laws are sovereign powers that have been retained by the states under the U.S. Constitution, and this allows the states to permit an on-ground invasion of their borders that is a threat to public safety and security. The on-ground violence and lawlessness at our southern border has been caused by the cartels and gangs is extensive, well-documented, and persistent. Therefore, it satisfies the definition of actually invaded an invasion of the Constitution. And two conclusions flow from this. First, the federal government has a duty to protect states under the invasion clause. Second, when the federal government fails to meet its constitutional duties, states retain the independent authority under the state self-defense clause to defend themselves when actually being invaded. There is nothing in federal constitutional or statutory law authorizing the federal executive to thwart the states from ensuring on-the-ground safety and an orderly border within their states. Nor is there any conflict with this and the orderly conduct of immigration policy by the federal executive. No state should ever be put in the position that border states have been put in through the federal government's recent actions. The federal government is failing to fulfill its duty under Article 4, Section 4 of the Constitution to defend the states from invasion. The state self-defense clause exists precisely for situations such as the one present. But please, let us always remember, the states created the federal government, not the other way around. And when the federal government refuses or neglects to protect its citizens, the states have an obligation and the ability to do so. Thank you.
Thank you, Mr. Brnovich. Mr. Hayek, you may begin. Can you make sure your microphone's on or the microphone's close?
Chairman Roy, Ranking Member Scanlon, and distinguished members of the subcommittee, thank you for the opportunity to appear before you today to testify on the vital and timely subject of what, under the Constitution, states may do about the border crisis. Overall, the Constitution provides well for this emergency, in my view, because it empowers the states to act in two ways. In the current circumstances, states may pass non-preempted laws to deal with this crisis, and they may also decide to engage in war. The Supremacy Clause of the Constitution provides that the Constitution and federal laws made in pursuance of it is the supreme law of the land. Potentially then, federal immigration law may preempt measures states take to deal with the border crisis. Despite this potential, the actual preemption picture at this time is not so dire for the states. This is very much because of what the states are trying to accomplish and the contrary thing the administration they are reacting to is trying to accomplish. The administration is in the poor legal posture of adopting enforcement policies calculated to achieve the direct opposite of the purpose of federal immigration law. That purpose is operational control of the border, and that is defined as 0 illegal entries. The law wants 0 illegal entries. The administration seems to want as many as possible. These policies clearly lack preemptive force. If a state interferes with the administration's efforts not to enforce the law, that is not the same as interfering with the law. A state is free to pursue congressional objectives that the administration has spurned, as long as it does not violate federal law while doing so. Take, for example, Texas's placement of razor wire to block illegal entries, at issue in one case now before the courts. This wire does not violate any federal law, and it is effective in achieving Congress's purpose in the immigration laws. It does not stand as an obstacle to those purposes, but only to the anti-enforcement purpose of the administration. Such executive enforcement or non-enforcement policies lack preemptive force, as the Supreme Court has clearly held. They are not the law and are not supreme. In short, there is much that states can do, including in the area of defensive barriers, even without invoking their powers of self-defense under the Constitution. Also, Article 1, Section 10, Clause 3 of the Constitution provides that without the consent of Congress, states may engage in war if actually invaded. Governor Abbott of Texas has invoked this provision and acted under it, declaring that his state is being invaded by the trafficking cartels, which are given cover and material support by the flood of illegal aliens from around the world who pay the cartels to smuggle them in. And decisions about these matters, in my view, are very much Governor Abbott's to make. There are strong grounds for thinking that whether a state has been invaded, and also what steps to repel an invasion are appropriate, is a non-justiciable political question to be decided by states, not the courts. In the 1990s, states such as California, Florida, and New Jersey sued the federal government for failing to repel the invasion of their states by illegal aliens, and thus violating the federal government's duty imposed on it in another constitutional provision to protect the states from invasion. The courts uniformly threw these cases out, holding that the question of whether a state had been invaded for purposes of this provision was a non-justiciable political question to be decided by the federal government, not the courts. The Constitution commits this question to political actors, and the courts lack workable standards for resolving it. By the same token, the question of whether a state has been invaded for purposes of Section 10 is a non-justiciable political question for that state to decide, not the courts. Here, too, the Constitution commits that question to political actors, and courts lack workable standards for resolving it. Likewise, the courts lack workable standards for deciding whether a given war measure, such as Texas's razor wire and floating barriers, is an appropriate means of waging war. That, too, is a non-justiciable political question for the state to decide, not courts, which are ill-equipped to decide war. Thus, following the example of the courts that threw out the invasion cases against the federal government, the courts should throw out cases against Texas's war because they present non-justiciable political questions. This question of war is one to be decided by political actors, not the courts. Thank you.
Thank you, Mr. Hayek. Mr. Jadwat, you may begin. Oh, okay, sir. Mr. Webster, you may begin.
Thank you, Chairman Roy, for the invitation today, and thank you also, Ranking Member Scanlon and distinguished members. I want to begin, first of all, by stating that I have the honor to serve as the First Assistant Attorney General of Texas under Attorney General Ken Paxton. We represent the state in all litigation. We also have proactively sought to hold the federal government accountable for their illegal actions in over 65 lawsuits. Currently, we're litigating more than a dozen cases against the open borders extremists in the Biden administration who have allowed illegal aliens, cartels, human traffickers, drug smugglers, terrorists, and transnational criminal organizations to bring chaos into America. While Texas has done its part to aid the U.S. Border Patrol, the federal government continues to fail us. The Biden administration refuses to exercise its power to deny entry, which predictably results in more and more individuals illegally crossing the border. It also incentivizes dangerous situations. As the Supreme Court has explained, an alien who is detained shortly after unlawful entry cannot be said to have effected an entry, and allowing aliens to enter by illegally crossing the Rio Grande into Texas, as well as Chicago, New York, and the rest of our country, will create a perverse incentive to enter at an unlawful rather than lawful location. This is very important for my testimony today because what matters is lawful ports of entry versus illegal entry. And the illegal entry is where the major harm is done. At no point is Texas contesting the right of any party to avail themselves of a legal port of entry. What's at issue is the invasion that occurs in the other locations that are not ports of entry. I encourage everyone listening to this hearing to read Chief Judge Aaliyah Moses's findings of facts in what is commonly known as the Concertina Wire case, as she lays out very, very dire circumstances and a significantly damning picture of the Biden administration's failure to enforce the laws Congress passed. Again, it is not Texas that is failing to abide by Congress's laws. It is the Biden administration that is failing to abide by Congress's laws. Now, to be clear, Governor Abbott has invoked his constitutional right to self-defense, and rightfully so. As a prosecutor, I was very aware of the dangers that the cartels faced, and I know that they control northern Mexico. So they have operation to control that area. They are functionally the government, the governing body of that area, and they are leading this incursion. They're interested in making money. They make money off of human trafficking, off immigration, drugs, you name it. They're down for whatever way, but their goal is to invade our nation. Now, Governor Abbott has invoked his right to self-defense, and he's adopted 3 strategies. First of all, Operation Lone Star. He has mobilized law enforcement and fought to reroute these immigrants towards the ports of entry and provide barriers and stop them from illegally crossing. As we know, that's a felony to illegally cross. And so he has placed those barriers up using manpower. He then used concertina wire. The Supreme Court of the United States has at no time ordered us to withdraw our concertina wire. That is false. We sued the federal government for cutting our concertina wire. And to read from Judge Moses's opinion, Border Patrol agents can be seen cutting multiple holes in the concertina wire for no apparent purpose other than to allow migrants easier entrance further inland. Any rational observer could not help but wonder why the defendants are the federal government, do not just allow migrants to access the country at a port of entry, which is only a mile away from where this concertina was laid. Instead of supporting our attempts to route these individuals to the port of entry and prevent the felony of illegally crossing at the border, the federal government has turned their guns against us and used their resources to sue the state of Texas for defending itself. They are snubbing their nose at Congress. They show up in the U.S. Supreme Court, and they argue that they have prosecutorial discretion to disregard the laws Congress passed in the 90s. Congress should care about that, and Congress should do something about that. And so I'm here today to ask help from Congress. Please help Texas. Please help stop this invasion.
Thank you, Mr. Webster. And now, Mr. Jablot.
Thank you, Mr. Chairman and members of the subcommittee, for the opportunity to testify on this important subject. For 150 years, the Supreme Court has been crystal clear. Regulation of entry into and expulsion from the United States are federal matters from which the states are excluded. From Chilong versus Freeman in 1875 to Arizona versus United States in 2012, the court has repeated this point over and over. States can't evade this rule by claiming they are merely stepping into the shoes of the federal government and enforcing federal laws. Again, this is black-letter law. In Arizona, the Supreme Court underlined that when a state purports to take over federal immigration enforcement for itself, it unlawfully violates the principle that the removal process is entrusted to the discretion of the federal government. If the rule were different, the already difficult task of managing and operating the immigration system would be infinitely more complex. No administration and no Congress would stand a chance of developing a coherent immigration policy, and the end result would be more chaotic and less effective by any measure. I'd like to turn to what we know about the actual effects of these kinds of state efforts. In Alabama, the one state where courts initially allowed a state immigration law like SB 1070 to take effect, terrified parents kept their children out of school, families lost their water service, immigrants were told by landlords that they were no longer welcome as renters, people were racially profiled by the police, brown people buying groceries were asked by checkout clerks for their papers, and children who did show up at school were asked why they hadn't yet gone back to Mexico. New verification rules meant long lines for everybody at DMVs and courthouses, and hassles for businesses seeking to renew their licenses. And what are we seeing today in Texas? According to the Wall Street Journal, Texas has spent years and billions of dollars on the most aggressive attempt by any state to take control over federal border security. There's no indication it has worked. Instead, and I quote the Journal again, it is precisely the areas of the border targeted most intensively by Operation Lone Star that have experienced the most rapid increases in unlawful border crossings since the operation began. While failing at its task, Operation Lone Star has not only cost billions of dollars, I believe the price tag is now over $10 billion, but it has imposed unjustifiable harms: mass incarceration, severe injuries, including a miscarriage, deaths from vehicle crashes, racial profiling, and more. As for the invasion hypothesis, the law contains no support whatsoever for the claim that the present circumstances amount to an actual invasion that inverts the Constitution's clear prohibitions on states engaging in war or taking over immigration enforcement. In fact, courts have uniformly rejected previous attempts by states to claim that higher levels of unauthorized immigration amount to invasion. And perhaps unsurprisingly, proponents of this claim uniformly refuse to grapple with the implication of their claim, that any governor can declare virtually anything, crime, drugs, pollution, dangerous goods, an invasion, and supersede federal laws at their will, or actually go to war against foreign countries or groups. And if that weren't sufficiently absurd, also, every court is required to accept the state's claim that its actions are therefore authorized by the Constitution. A federal judge recently called this whole thing breathtaking and soundly rejected it. And indeed, if ever an argument proved too much, it is this one. It would destroy the Constitution's principle of federal supremacy and its careful delineations of the war power. The invasion claim is made up and incredibly flimsy. And the fact that some state officials are reaching for it now simply underlines that there is no legitimate way for them to do what they want to do. Thank you, and I look forward to your questions.
Thank you, Mr. Jabawat. We will now proceed under the 5-minute rule with questions. The chair recognizes the gentleman from California for 5 minutes.
Thank you, Mr. Chairman. It should be obvious to all of us that the nation that will not enforce its immigration laws has no immigration laws. If it has no immigration laws, it has no borders, and if it has no borders, it ceases to be a nation. This is the crisis that the Biden administration has unleashed by its deliberate decision to open our borders to literally millions of illegal migrants. Its effect is now being felt across the country. Its impact on our schools, our hospitals, our social safety net, law enforcement, public safety, and national security is absolutely catastrophic. One part of the crisis caused by this administration is before us today. It's the constitutional tension between the governments of the states that bear the burdens of mass illegal migration and the federal government that has caused it. Fortunately, though, we've got a Constitution that establishes institutions that are designed to resolve these tensions, these disputes, and the greater the strain that these issues place upon us, the closer we need to hew to that Constitution. Immigration law is an enumerated power of the Congress. That should be indisputable. National defense is an enumerated power of the Congress. That, too, should be indisputable, with the exception of an actual invasion when states retain their sovereign right to self-defense. But at the center of today's hearing is how do we resolve these disputes arising under the Constitution, and that's the reason we have a third branch of government. This question is the rightful province, not of the U.S. Congress, but of the U.S. Supreme Court. Under our Constitution as Americans, we owe to it, in the words of the Mayflower Compact, all due submission. So this brings me into agreement with the minority on this narrow but critical point. The Constitution must be upheld in all matters. The Supreme Court has ultimate jurisdiction over legal disputes arising under that Constitution, and this is never more important than when we're in a crisis, and this is a crisis. Let me ask the majority witnesses, what am I missing? Go ahead.
You're missing that the courts don't decide everything under the Constitution.
No, they decide disputes arising from the Constitution. This is a dispute between the state and federal governments over what constitutes an invasion and what measures the states can legally take within the sphere of the enumerated powers of Congress involving national defense and immigration.
Right. Courts decide cases in court, controversies in court. If this goes to court, and it is before the Fifth Circuit now.
Well, it's a dispute arising under the Constitution, isn't it?
Yes.
Where else would be the constitutional form to resolve such a dispute?
We don't disagree about that, but what courts can do is say that this issue is not justiciable, it's a political issue, and send it back to the states. The
courts
or the
could
federal
do
government.
that.
The courts were not interested in talking about what an invasion was.
The courts, you're absolutely right. The court, but that still is the province of the courts, not of the Congress, not of the administration, and certainly not of the states.
I would agree. I would
Okay,
just,
good. Well,
I would just
I'm glad to hear
resist
that. Let me
punting to the
just
courts.
go on. First of all, any other thoughts from the other majority witnesses?
I think Congress could authorize the states to enforce immigration under their congressional powers.
It could, exactly right. And I think that's the whole point. Congress can enact new laws in concert with the Constitution. It can propose changes in the Constitution to the states. And from that standpoint, you're in the right place. We're the legitimate place to propose changes to the Constitution or to change the laws under that Constitution. The fact remains, the issue's not going to be solved, though, by bills that won't be signed or laws that won't be enforced or funds that will only be used to expedite more illegal entries into the country without expelling any. And it's not going to be solved by replacing one leftist official with another. It's going to be solved by the American people electing an administration that's actually dedicated to enforcing our laws, upholding our nation's sovereignty, and defending our country. But this is not a place to resolve the disputes arising between the states and the federal government. That belongs to the courts. The enforcement belongs to the executive branch. It is not doing its job. This was set in motion by the American people that elected that administration. I tell them, you know, if you voted for this administration, this is exactly what you voted for. And if you're surprised by that, you weren't paying any attention, because this is exactly what they promised to do. This is exactly what they've done. And this is exactly what they've defended for the last 3 years. Thank you, Mr. Chairman. I yield back.
Thank the gentleman from California, and I now recognize the committee ranking member, Mr. Nadler.
Thank you, Mr. Chairman. Mr. Chairman, I find myself in rare agreement with Mr. McClintock, not on the subject of immigration and not on the actions of the Biden administration, not on the causes of what's happening, but on the constitutional question, which is clear. Mr. Jadwat, is there an open legal question as to whether the states have independent authority over immigration and foreign policy, or is it clear that the Constitution gives the federal government primacy over these matters?
No, Mr. Congressman, it's clear that that is the federal government's job.
And generally, how would you characterize the Supreme Court's rulings in cases where the federal government has challenged state regulation of immigration matters on the basis that such regulations are preempted by the Supremacy Clause and federal law? Have they been more favorable to the federal government or to the states?
To the federal government.
And how would you characterize these rulings in general?
Again, I think it's clear. The court has reiterated time and again that this is an area where the federal government has exclusive authority, and that states can't enact their own rules or purport to step into the shoes of the federal government and enforce federal laws.
Thank you. Now, the premise of this hearing is that we are faced with an invasion from abroad, a foreign invasion, and that the states have the power under the Constitution to repel an invasion. Now, multiple federal courts have presented with this question, have concluded, in the words of the Circuit Court, of the Third Circuit rather, quote, that there is no support for reading the term invasion to mean anything other than a military invasion, unquote. Mr. Jadwat, has there been any military invasion of the United States? Any foreign armies crossing our borders recently?
No, sir, not to my knowledge.
Not, in fact, since 1814.
I'll take that, yeah.
Yeah, I would not include the Confederacy. That was a civil war. Now, is there any question that the term invasion does not refer to what's happening now because there's no military force invading us, and that whatever is happening at our border, however you want to characterize it, is not an invasion under the meaning of the Constitution?
Yeah, I think that's clear both under, the decisions of the courts that have discussed that question and under the plain terms of the Constitution itself.
So there is no basis for Texas or any other state claiming authority to do anything other than what the federal government does in this area?
That's right.
It's correct.
Yeah.
Thank you. Are you familiar with the Great Replacement conspiracy theory?
Yes.
How does the argument we heard here today that there is a, quote, actual invasion of the southern border feed into this racist conspiracy theory?
I think that when you talk about people invading the country, poisoning the blood of America, those sorts of terms, it adds fuel to the fire of these kinds of theories. But I also think in particular, when you think about the term invasion, right, it paints the so-called invaders as violent. And even more so, it authorizes violence against those people. In war, we can do things that would be illegal in any other context. Killing, violence, all sorts of terrible things. And according to the folks at this table, they're not speaking metaphorically. They're not just using rhetoric. They are actually authorized to engage in war against people who are coming to this country. That, I think, is profoundly dangerous.
So you think that promoting this actual invasion argument is not only wrong as a matter of law, but potentially dangerous to innocent people and to the country as a whole?
Yes, I do.
Let me ask Mr. Hadjic, given the court's uniform, every decision I'm aware of, interpretation of the term invasion in the Constitution as meaning a foreign invasion by a military force, how do you justify Texas or any other state's independent actions in this area?
But by the Constitution, it's the only there's no sort of law of war, Clausewitzian definition of invasion that has anything to do with that constitutional
I just quoted
provision.
the Third Circuit that says no support for reading of the term invasion to mean anything other than a military invasion. And every other court that has addressed this issue has said the same thing. You're saying that every federal court you're saying that every federal court is wrong, and you're right.
The courts that have said that, I believe, are wrong. The Constitution simply uses the word invasion, and it would carry its meaning in ordinary language.
courts-
and if you look at dictionaries at the time,
And forget dictionaries. Our courts interpret the Constitution, and authoritatively, and our courts have interpreted the
Constitution
phrase
belongs to the
invasion to
people.
mean a foreign military invasion, and anything to the contrary is nonsense. I yield back.
The chair will recognize myself for 5 minutes for questions. Let me just ask each and every one of you a question. The 3,000 plus Americans that died on September 11th, do you think they're comforted by the definition of invasion that has been posited by the ranking member? Just go down the line. Mr. Brnovich, do you think they're comforted by that definition of invasion?
Well, I can't speak to other members of the committee, but I will just say that obviously the president is at the apex of his or her power when it comes to border issues and immigration. So I feel like there's two ships passing in the night.
This
is an issue related to security, border security, not immigration.
All right, Mr. Brnovich, question. 3,000 Americans were killed. People are trying to say that there's a specific invasion that we haven't been invaded since 1814. Do you think the families of the 3,000 who were killed would suggest that what happened on September 11th, the product of overstayed visas and a bad system that we have here in terms of protecting against unwanted attacks, that is an invasion from the standpoint of any logical conclusion of an American who's concerned about their safety and well-being?
September 11th was an invasion and an attack on the
Mr.
United
Hayek,
States.
would you think so?
I would think they would not be comforted.
Right. Mr. Webster?
It was an invasion.
Right. Now, Mr. Jabwat, yes or no?
I wouldn't purport to speak for the families the people who were killed.
Right. Do you think as an American, it was an
So-
invasion to have people come in and bomb buildings, fly planes into buildings, and kill
Within-
3,000 people?
You know, within the meaning of that clause of the Constitution.
People who overstayed visas.
Within the meaning of that clause of the Constitution, because I agree with everybody here, it was an attack. I was blocks away
So,
when it
so is
happened.
that a yes or no? No. I mean, you're saying no then.
Not with it, I don't think so,
Right.
not within.
So for the average American watching this, and they're saying, okay, that is how we have to live in the modern world. Say that, okay, unless the redcoats are marching right in, coming right up in through New York, coming up the river and saying, okay, we're here, right? Or unless there's a army with, coming across the Rio Grande, that's the invasion. But when 3,000 Americans are dead because we were attacked by people who overstayed their visas because we have a very broken immigration system, or we now have people who are going around the country that just end up in Minnesota, who've been here for a year, that are clearly affiliated with terrorist organizations, that somehow we don't have to be concerned about whether or not that's an invasion, right? Do you believe that President Biden is responsible for the crisis at the southern border? Yes or no? Mr. Brnovich?
Absolutely.
Mr. Hayek?
Yes.
Mr. Webster?
Yes.
Mr. Jabwat?
No,
President Biden responsible for the crisis at the southern border?
President Biden is responsible for the policies of his administration.
So is he responsible for the present crisis at the southern border?
And to the extent that his administration,
Is that a yes or no?
would you let me finish?
I mean, yes or no? Is he responsible for the crisis at the southern border?
He's
He and-
responsible for the policies of his administration and their effects at the
Well, I'll take that as a yes then. Is the Biden administration responsible for the border crisis this country is facing? That, I think, was a yes. Do you believe that what is currently happening on the southern border constitutes an invasion, as we understand it in the Constitution and is applied in today's world, where we're dealing with the forces that we're dealing with around the world, with forces who want to endanger the American people? Mr. Brnovich, yes or no? Is what is currently happening on the southern border an invasion?
As our first in the nation opinion expresses, this does constitute an invasion pursuant to the U.S. Constitution.
Thank you, Mr. Brnovich. Mr. Hayek?
Yes, because the cartels are committing hostile encroachment onto Texas, and that constitutes an invasion.
Thank you, Mr. Hayek. Mr. Webster?
Yes, absolutely.
And Mr. Jabwat, I think we know the answer. You believe it's no.
Not within the meaning of that
And so
clause of the Constitution.
here's a question. Do you believe that states like Texas or Arizona or any other state has a right to defend their citizens and take action to secure the border, particularly in the complete and abject failure of the federal government to do so, as the Constitution contemplated, notwithstanding the views expressed by some on both sides of the aisle to the contrary? Yes or no, do the citizens of those states have the right to defend their citizens and take action to secure their border? Mr. Brnovich?
The governor does indeed have the ability to call out the National Guard or use state resources to protect the citizens of their state.
Mr. Hayek?
Yes, it's clear that right is clearly stated in the Constitution.
Mr. Webster?
Yes for Texas.
Mr. Jabwat?
Again, 150 years of Supreme Court precedent says that states do not have the authority to take immigration matters into their own hands. And
Was
no
Dred Scott a good
no
opinion?
governor has the right.
Was Dred Scott a good opinion that we should follow?
We're not talking about Dred Scott here. We're
Do
talking
we,
about
next
150
question.
yards.
Do we, right, what, but,
And no
but it does
governor,
matter.
and no governor has the authority to override that Supreme Court
But that wasn't the
precedent
question.
or
That wasn't the question. Mr.
Constitution
Jabwat, with all due
by
respect, that wasn't the
claiming that
question.
an invasion
Your
is
time,
taking
your time
place.
is up. You've answered the question. We know where you stand. Do we have operational control of our southern border as defined by the Secure Fence Act of 2006, which states operational control means the prevention of all unlawful entries in the United States, includes entries by terrorists, other unlawful aliens, instruments of terrorism, narcotics, and other contraband? Yes or no? And then I'll finish my questions.
No.
Do not.
Mr. Jabwat?
No, and we never have, and we never will by that definition.
Well, at least that's consistent with Secretary Mayorkas, who told me under oath in this room that he did have operational control. With that, the gentleman from Tennessee.
Thank you, thank you. I'm going to ask Mr. Webster, because he's from Texas. Most of the immigration is coming through Texas, is it not?
Currently, yes.
And are most of those immigrants staying in Texas?
There are a lot of them staying in Texas, but they are routing throughout the country. It's affecting the whole nation.
But are most of them staying in Texas?
No.
Where are they going to?
Well, you'd have to ask each one of them where they're going.
I don't have time for that. You should have an idea.
I do know that the mayor of New York has expressed concerns about how many are arriving in his city, so
Because
there's a lot there.
either Governor DeSantis or your governor have put them on airplanes and sent them to New York, buses, airplanes, whatever, and sent them to Chicago and sent them to Denver. Other than those those vacation tours that your governors have planned, where are these people going?
Well, you'd have to ask the Biden administration. They also bus individuals and fly individuals into the interior. Also, the local cities do as well. San Antonio, El Paso have all bused and brought people out of Texas, out of their cities.
I would suspect most of them are staying in Texas, more than any other state. And yet I read these proposals by certain Republicans, and Mr. Roy kind of got into it as well, that by mentioning Ms. Clark, that the Democrats allegedly are all in favor of the immigration folks, people coming into our country, because they want them to come into their districts for the census in 2030 to get more Congress people and more money. But most of the people are staying in Texas. And so it seems like Texas would get the congressman and Texas would get the money. So it doesn't make any sense that these states, and in fact, New York doesn't want them, and Chicago doesn't want them, and Denver doesn't want them. So they're obviously not caring about the 2030 census. Is it Jadwatt? Have you heard these theories about the 2030 census and the reason the Democrats are doing this?
This is actually new to me.
It's new. Well, I read it. Marcia Blackburn, one of my senators, wrote that you might wonder why Democrats want to leave our border open. Explanation is straightforward. Blue states know they're on track to lose congressional seats and federal tax dollars when the next census is tabulated. By taking in undocumented immigrants who count toward the census population, Democrat-run states can help offset these losses and retain their congressional seats and federal funding. Is that loony?
It seems far-fetched to me.
And most of the immigrants are staying in the red states, Texas and Arizona, and I guess they go to California. I mean, why not? I mean, that's blue state. Anyway, neither here nor there. The main thing about this hearing, which is astonishing to me, is we've got a bill in the Senate that they're working on, which will be the most comprehensive reform of border security ever. President Biden has said that he will sign it and he will close the border. That's what I think the Republicans want. That's what I think they've campaigned on. But now Mr. Trump doesn't want that to happen. So when he talks to Speaker Johnson, he tells him, stop that bill. We don't want to have an immigration bill because it might help Joe Biden say, I've worked on the immigration crisis and I've helped stem it. So instead of working to help our country and stop the invasion, there's an invasion on our southern border. But we don't want to stop the invasion until Mr. Trump gets a chance to deal with his border issue. And we all know what Mr. Trump's border issue is. It's the security fences around the prison that he's going to go to if he doesn't get elected president. That's his border issue. He doesn't want to have to deal with that border. And for that reason, we're going to let the invasion on the southern part of our country continue. Let all these people come in who are raping our women and cheating our friends and doing all these terrible things and ripping off veterans. We're going to let that happen until Mr. Trump can see to it that he doesn't go to the big house with the borders that he fears. It's just insane that we don't look after our country, which we should, and we should encourage the Senate, which they would do, to pass their bill. Mr. McConnell says it's the best bill they'll ever have. So does Lindsey Graham. Quite a few Republican senators are working on this. Langford, they all want to pass it, and they say they're going to get a much better bill than if they wait till the next administration, if there is a next administration, that this will be the best bill possible. And you always know the legislation is evolutionary, so you accept a bill. Anyway, this is just, we need to focus on the real issues, which is passing a border bill, protecting our border, protecting our country, and that would be passing a bill that the Senate has, which is a good bill, and getting it in the House and passing it here and not listening to Mr. Trump. I yield back.
Thank the gentleman from Tennessee. I'll now recognize my friend and the gentleman from California.
Thank you, Mr. Chair. I have a question for Mr. Jedwat, the witness with the ACLU. If I'm to understand your position correctly, you're opposed to governors mobilizing their National Guard to secure the border. Is that correct?
I wasn't talking about the National Guard. I was talking about state efforts to actually do immigration enforcement.
I see. So I have a press release here from September of 2023. It says, Governor Newsom increases California National Guard presence at the border to crack down on fentanyl smugglers. Would you take that? Would you say that action by Governor Newsom is appropriate and within the bounds of his authority?
It might be. Yeah, I mean, I have no familiarity with what is referenced in that article.
The press release again, it says Governor Newsom increases California National Guard presence at the border, cracking down on illegal drugs, including fentanyl being smuggled into California. Governor Newsom is increasing the number of California National Guard service members deployed to interdict drugs at U.S. ports of entry along the border by approximately 50%. Governor Newsom said fentanyl is a deadly poison, ripping families apart and communities apart. California is cracking down, he said, and today we're going further by deploying more CalGuard service members to combat this crisis and keep our communities safe. So the governor saw a public safety issue arising from the situation at the border and mobilized the National Guard to try to keep our communities safe. Would you say that was appropriate by the governor?
It probably would, and I would point out that, you know, what we're talking about there, fentanyl, at the ports of entry, you know, that's where the fentanyl is, and that's where the focus ought to be, to the extent that that's the
Okay, but you're
concern.
making a policy judgment as to what's the greatest, the most effective thing to do.
No,
I'm asking you about his
I'm pointing
authority
out
to do
that as a
Does he have the
factual
authority?
matter, you know, CBP, the Cato Institute, everyone who's looked at the question agrees that approximately 90% of the fentanyl that's going
Okay, but again, that's not what I'm asking. I'm
It's
asking
happening
about
with
his
DOEs.
authority. Do you agree he had the authority to do that?
Again, I don't know the details of that, but it sounds like what was happening was that he was deploying the National Guard either in cooperation with the federal government to assist them at POEs, which, you know, sounds like a reasonable thing to do.
So we have the former Attorney General of Arizona, first Attorney General of Texas here. Would you say that in some sense, your governors, either at the time or now, were simply following the Newsom precedent, that he saw a public safety risk arising from the border and so made use of California resources to assist?
Well, Texas would never follow California precedent.
Fair enough.
But it's the similar strategy.
Yeah, yes, clearly, states, even states like California, want to do everything they can to protect the citizens within their states. And that means at times they will deploy the National Guard. It means at times they will deploy Department of Public Safety or state police officers, because I think even the state of California recognizes that there is an unprecedented amount of illegal drugs, of illegal human trafficking coming into our country. And because of that, the cartels have seized operational control of our southern border. And as a result of that, every American is less safe, and every child is more in danger of dying of a drug overdose.
Thank you. Mr. Jedwat, you also testified that states do not have the authority to take immigration matters into their own hands. You said the Constitution prohibits state regulation of immigration. You said that entry, exclusion, and deportation are exclusively federal matters. Federal officials, you said, decide whether it makes sense to pursue removal at all. Would the same logic apply to states or other jurisdictions that have adopted so-called sanctuary policies, where they actively interfere with federal immigration enforcement? Can we assume, based on your testimony, that you oppose those efforts as well?
I don't think you should assume that, because I think what so-called sanctuary policies are generally about is states opting out of federal enforcement. And that's an authority that states have under the 10th Amendment that protects states against commandeering by the federal government. So, for example, if the federal government said to Texas, we want you to take your land and your personnel and build a processing center on the border, Texas could say, no, thank you. And that's what states and cities are doing with their sanctuary laws. No, thank you. We're not going to use our police.
Okay, but that's
or our
different.
facilities.
Under sanctuary policies, for example, in California, we had someone who was arrested, was in custody. ICE asked to know when he was going to be released.
And the sheriff's office said, we can't tell you because of the sanctuary state law. That individual was released the next week. He killed his own 3 daughters and their chaperone. So that seems like it's pretty actively interfering with the federal decision to pursue removal in this proceeding, does it not? And so by the very terms of your testimony, that is something that would be unlawful as well.
I mean, again, it sounds like from what you said that the federal government asked the police to do something and they said no, or the sheriff to do something and they said no.
Taking the decision out of the hands of the federal immigration
And that's,
authorities,
again,
correct?
the anti-commandeering principle that was elucidated by the Supreme Court in Prince versus United States, which was about sheriffs not doing the federal government's bidding in enforcing gun regulations. It's the same principle that applies here.
Thank you. My time has expired. I yield back.
Thank the gentleman from California. And I now recognize the gentlelady from Texas.
Thank you, Mr. Chairman, and many thanks to our panel. I represent El Paso, Texas. I'm the only member of this committee who lives on the U.S.-Mexico border. And in fact, it's been my community that has had the highest numbers of apprehensions and encounters, and we probably will again this year. This hearing is a very brazen effort to provide political cover to my governor, Governor Greg Abbott, who has unconstitutionally used state resources in order to try to impose the state's own immigration policies and laws. The current amount being used by the state is $11 billion. $11 billion of state taxpayer money. And I think we can all agree, because witness said earlier, Texas has the highest number of encounters. That's true. El Paso, the highest number of encounters. Obviously, what Greg Abbott is doing is an absolute failure. And there's nothing about what Greg Abbott is doing that is about trying to improve the situation, trying to solve a great challenge. It's all about political posturing, which is what this subcommittee has become about, which is what this committee has become about, and it's unfortunately about what this Congress has become about. And it's really tragic, because our nation deserves bipartisan solutions that make sense and that help our country. Instead, what we're doing here today is advancing a crackpot legal argument that is itself based on a racist conspiracy theory. And that theory, the argument, is rooted in the repeated cries of an invasion, which is a dog whistle for the Great Replacement theory. The Great Replacement theory actually was a motivator for a white supremacist who drove to my community and slaughtered 23 people and injured dozens more. So there's deadly consequences to this kind of hate speech. Why else would the majority invite a witness whose organization is linked to a right-wing anti-immigration organization founded by a white nationalist, if not to promote these theories? Mr. Jadwat, I'd like to ask you, are you familiar with the Great Replacement conspiracy theory?
Yes.
How does the argument that there is an actual invasion at the southern border feed into this racist conspiracy theory?
So I think it dehumanizes people by treating them not as people, but as invaders. And as I discussed before, it paints them as violent when I think everybody here would agree that the vast majority of people who come to the border are not. And it authorizes violence against them. And that is the truly dangerous piece of this language. And again, the contention here is it doesn't just, this is not a rhetorical point. This is not a metaphor that they're using. They're saying, as a matter of law, that we are authorized to use the tools of war in responding to what we have termed an invasion. And you know, I think you heard, you know, this comparison to, defending your home against an invasion, and how you wouldn't look at the Constitution or the statute books before you took matters into your own hands and responded with violence. And that is not the way that we can or should be responding to what's happening on our border. As you know, as somebody from a border community, the sort of chaos and violence that would be unleashed if that were the rule would be profoundly, profoundly destructive.
And I'll close by saying it already has been. And the survivors of the August 3rd, 2019 massacre in El Paso, Texas, can testify to just how destructive and dangerous that kind of language is. I yield back.
I thank the gentlelady from Texas, and now recognize the gentlelady from Wyoming.
Thank you. Mr. Brnovich, you stated a moment ago that states want to do everything they can to protect their citizens. Would you agree that every single member of Congress should also take whatever steps are necessary to protect their citizens?
I believe every member of Congress takes an oath to swear and uphold the Constitution of the United States, and that includes protecting their citizens within their states or districts.
And Mr. Jadwat, you defend sanctuary cities under the concept of the 10th Amendment, which I'm really excited to hear a liberal talk about the importance of the 10th Amendment. I think we could have a lot more discussions about what we ought to be doing under the 10th Amendment. But you use the 10th Amendment claiming that it is an anti-commandeering theory. But isn't that exactly what the Biden administration is doing, is commandeering the resources of Texas and Arizona and every other state in the nation to absorb the costs associated with illegal immigration?
So commandeering refers to actually...
I want you to answer my question.
Well, no, not under the legal definition.
When Texas has to use its resources to absorb the costs associated with illegal immigration, isn't that commandeering?
Not within the meaning of the
Okay,
10th
then I'm not going to bother with you if you're not going to actually engage on the terminology that you use. Mr. Brnovich, in February 2022, you drafted an Attorney General opinion on the federal government's duty to protect the states and the state's sovereign power of self-defense when being invaded. One of the questions you address is what constitutes actually invaded for the state self-defense clause and invasion for the invasion clause. Mr. Brnovich, what do you conclude the scope of invasion means in the Constitution, and does the Constitution's contrasting of invasion with insurrection, rebellion, and domestic violence create a situation where it can be applied to non-state actors?
Our opinion lays forth the distinction between domestic insurrections and rebellion versus an actual invasion. If you go back to the Federalist Papers, which were designed during the constitutional ratification, the debate in Federalist 41, Federalist 42, Federalist 43, James Madison set forth clearly that invasion constituted not only state but non-state actors. And in fact, during the ratification, during the Virginia ratification debate, one of the examples future President Madison used was the fact that there was pirates and smugglers off the coast of Virginia, and that Virginia had a right to defend itself against people that were breaking the law. And if the federal government and the federal Navy, just non-existent at the time, couldn't do anything, then the state of Virginia could. And so, and even a lot of the conversation and the discussion we've had today is about whether states can enforce immigration law. The reality is that the federal government, the president has had his or her height of power when it comes to immigration law. However, the courts have never said that states do not have the ability to protect themselves, that states do not have the ability to stop or repel an invasion. And if you read our opinion, we lay forth not only the facts, and we've heard so many facts from this Congress about the number of people dying. I mean, my goodness, more than 100,000 Americans dying from fentanyl and drug overdoses. We've seen a spike in Arizona in just the last 5 or 6 years from single-digit percentages into above 50% when it comes to those deaths. We've seen a spike in violence. And anybody, I would urge you to come to the southern border. And when you see rape trees where women are being victimized and traumatized by human smugglers and the drug cartels, you will ask yourself, why isn't this Congress, why isn't this administration doing more, not only to protect our citizens here, but also to stop people from being exploited by the cartels and gangs?
It's an incredibly inhumane situation that has been created by this administration. Joshua Trevino of the Texas Public Policy Foundation clarified that invasion means entry plus enmity, and the action of modern non-state actors can meet this threshold if they reach a scale where they overthrow or curtail the lawful sovereignty of a state. Mr. Brnovich, you were the Attorney General of Arizona, where you served as the Chief Legal and Law Enforcement Officer. Can you speak from your experience about whether the actions of the cartels displace state sovereignty and constitute entry and enmity?
As you know, the states are absorbing a cost, not only fiscally, but a cost in human treasure as well. We just talked about the tragic drug overdoses and the drug deaths. We've also seen a spike in violence. If you talk to the sheriffs, not only along our southern border, but sheriffs in places like Pinal County, they will tell you they've seen a dramatic increase in the number of car pursuits and car chases, which also are dangerous to our community. And it seems like every day now you see a video of literally cartel members escorting people across our border. So as every day goes on and the administration refuses to act, the cartels are getting more and more powerful. They have made billions, if not trillions of dollars off of the last 3 years and what's happened. And as a result of that, my worry as an Arizonan and as a first-generation American is that Mexico is on the brink of becoming a narco state.
Thank you. I appreciate it. Yield back.
I thank the gentlelady from Wyoming. I'll now recognize the gentlelady from Vermont.
Thank you, Mr. Chairman. Let's talk about invasion. Let's talk about the invasion of the U.S. Capitol on January 6, 2021, when the heart of American democracy was attacked by a mob, many of them violent, of then President Trump's supporters who fought to keep him in power illegally. The evidence is overwhelming. And yet many, many Republican members of the House not only continue to deny the truth, but still will not admit that Joe Biden won the 2020 election. This includes our current House Speaker, who even as recently as several weeks ago refused to affirm that Joe Biden won the 2020 election and is the legitimate president of our nation. The Speaker of the House. And it includes another member of GOP House leadership who has taken to calling those imprisoned for their illegal actions on January 6th hostages. Hostages. They attacked our very democracy, and yet they are the victims? It's morally bankrupt. This is not only a sick, twisted perversion of the truth, it's also deeply offensive to Americans across this country. What my extreme MAGA Republican colleagues and their apologists are doing is perpetrating a deeply cynical, psychological manipulation. They tell us we can't trust our own eyes, that the men and women in uniform here at the Capitol were not battered and bloodied by the mob. They tell us that it's not true that members and their staff were hiding in fear for their safety, that it's not true that Democrats and Republicans on that day knew that they were in danger, and that the president, who incited the riot and the invasion and the insurrection, they knew this truth. And they said on that day, we're done with this guy. We know the role that he played. We're done with this guy. They knew his role. They saw it up close, and then they backpedaled and apologized for Trump and spread misinformation. So I find this offensive as a public official who has sworn to uphold the Constitution, but it's also deeply concerning as an American who cares deeply about this country and the Constitution. So you have to forgive me. You got to give me a little grace here for not being able to take this hearing seriously. This hearing, as we've said, is an absurd legal argument. The Constitution is clear. The federal government is supreme in matters of immigration and border policy. And with all due respect to Chairman Roy, I believe that his call for Texas to ignore the Supreme Court is an endorsement of lawlessness and chaos. I am a thoughtful and committed public servant. Yes, we need a secure border. Yes, we need humane border policy. We need immigration reform. We need more legal pathways for migrants to work. Yes, we are a deeply divided Congress, and we must work in a bipartisan manner to actually solve the immigration issues that have plagued us for decades. And yet, that's not what this hearing is about. And it's worse than a distraction. It's worse than a waste of time. It's actually an insult to Americans everywhere. Right now, senators, Republicans, and Democrats are working on a compromise immigration bill. Right now, the president has said that he is prepared to sign a bipartisan immigration bill. Right now, the president has said he will put an additional $14 billion into securing the border. What has been the response for my Republican colleagues in the House? No. The response is no. Trump doesn't want it, so we don't want it. We don't want a solution. We don't want to alleviate suffering. We don't want to actually secure the border. So you have to give me some grace. You got to forgive me for not believing the calls for this being such an emergency. A bipartisan group in the Senate says, we have a solution. The MAGA response has been, let's keep the chaos, we're good. Let's keep the suffering, we're good. This supposed extreme danger doesn't seem so extreme as I sit in this hearing because it's not good for the ex-president. So again, forgive me for not taking this hearing seriously. Our Republican colleagues have made it clear repeatedly that they will not work in a bipartisan manner on actual immigration reform. I yield back.
Well, I thank the gentlelady from Vermont. Since my name was invoked, I'll just note that Border Patrol agents reach out all the time, and they are thankful that the razor wire is being implemented by Texas, so keep it up. I will now yield to the gentleman from South Carolina.
Thank you, Mr. Chairman. I'd like to yield 2 minutes to my colleague and good friend from Arizona, Mr. Biggs.
Thank you. Appreciate yielding to me. I'm going to ask you, Mr. Brnovich, is it absurd on its face to argue that the same federal government that is not protecting the sovereign state from an invasion under Article 4, Section 4 also gets to determine the definition of what constitutes an invasion?
Mr. Biggs, yes, I think that is quite the dilemma the administration has. And I think most Americans and most Arizonans that I talk to ask me, why was President Biden so quick to tear down the border fence in Texas, but so slow to shoot down a Chinese spy balloon? And I think that that's an indication of where the priorities are for this administration. As you know, in Arizona, we see every day, we deal with constituents, former constituents, people that have lost a loved one, very often teenagers, young people, as a result of the fentanyl pouring across our southern border. We've seen a rise and a spike in violence. And so if the federal government is unwilling or unable to do its job to secure the border, then I think the states have every ability to do so.
It has previously been defined, one definition of invasion is an encroachment upon rights of another. So I guess I would ask, you're in Arizona, I've got 30 seconds left. Is the environmental damage caused by hundreds of thousands of people illegally entering the country, littering, tramping over actually natural wildlife preserves, destroying those preserves, might that constitute the damage, encroachment of the rights that constitutes invasion?
Yeah, Congressman Biggs, we actually made this argument when we sued the Biden administration over its failure to build a border wall. There's an average of 8 pounds of trash per person left at our southern border. So not only are people that are crossing the southern border destroying Arizona and Texas and other natural habitats, they're destroying game trails, and they're leaving very often behind plastic bottles, gasoline tanks, all sorts of other items that are non-biodegradable and do constitute a threat to the environment and animals living in those regions.
I yield back to the gentleman from South Carolina.
Thank you, Mr. Biggs, and I'm going to piggyback on, I think you were going to make a comment, General, about replacement theory earlier, and you were out of time. Do you care to comment on that, sir?
Yeah, thank you very much for that question, Congressman Fry. I will tell you, as a first-generation American, I find it very insulting for people to assume or accuse people up here, including myself, of somehow advocating some theory. What I do know is someone that grew up speaking Serbo-Croatian as my first language. I think it wasn't until the 4th grade that I realized my name was Brnovich and not Burnowich or Brontosaurusvich or any other words that rhyme with that. And that's just what the teachers called me. And I will tell you, this is a nation founded upon the rule of law. And what we are seeing right now is that shredded in the process. As Americans, we don't have a common religion. We don't have a common ethnic identity. but we are founded on these sacred documents, the Constitution and the Declaration of Independence. And that's what binds us together. And anytime you have a process that not only creates a threat to public safety, as we've seen with the gangs and cartels seizing operational control of our southern border, and that affects all of us, but we also see in this process of the president's failure and Secretary Mayorkas's failure to do their job, a shredding of the U.S. Constitution. So the very reason why people are coming here, because no matter who you are or where you come from, you can become an American. It is being shredded in the very process, and the rule of law is being undermined by the chaos that's occurring at our southern border.
You're right, and it's frustrating, General. I'm struck just being in this committee room today, quite frankly, that my colleagues on the other side seem to be suffering from a little bit of amnesia, because it wasn't long ago as a freshman that I sat down there in my first hearing, and the comment was made by the ranking member that Republicans were imagining a border crisis. And this wasn't like 5 years ago or 10 years ago. This was last year. And so the amnesia has struck, and now all of a sudden they're border hawks, and they want to have us accept a Senate deal, which doesn't seem to be a deal in any which way for the American people. You know, what's interesting to me is we have always had an effort by the feds under Republican and Democratic administrations to fix the issue, right? Even the former Secretary of Homeland Security under Obama said that if 1,000 migrants come in today, that's a crisis point. But they want us to accept in a deal that 5,000 and then they'll shut down the border. So let me ask you this. Considering that the federal government, General, is not doing its job, what remedies do states have to pursue fixes to this, because the burden is heaviest on those at the southern border?
Congressman, this is exactly why the reason I think states like Texas have done this very reluctantly. I mean, as you said, this has been going on for years, and for years the states were waiting for the federal government to do its job, and it refuses to do so. So I think it's incumbent on Congress to either impeach federal officials that are refusing to do their job, to cut off funding for those agencies, or alternatively, I mean, even during the Obama administration, during the Bush administration, you had Operation Streamline. I mean, the laws exist where if there was a surge essentially to our southern border, I wish we worried more about our southern border than the border between Russia and Ukraine. If there was a surge to our southern border with prosecutor and judges, once again, you would see a dramatic decline in the number of people illegally entering the country. So the answer to this question, it shouldn't be. The states shouldn't have to do the job, the federal government won't. The answer, though, is clearly that the Biden administration won't do its job. The states are frustrated, people are dying, there are expensive costs not only in human treasure but in real treasure, and that's why states like Texas are finally acting.
Correct, $1,100 per American citizen. That's an astronomical amount. With that, Mr. Chairman, I yield back.
I thank the gentleman from South Carolina. I will now recognize the ranking member, the gentlelady from Pennsylvania.
Thank you, Mr. Chairman. I just wanted to try to clarify some of the points that have been made throughout the debate. The gentlewoman from Wyoming raised Mr. Baranovic's writings laying out his position with respect to the fringe legal theory about invasion that we've seen pressed in this hearing. And we continue to want to point out that this is a political argument, that it is not a constitutional argument, and I would seek unanimous consent to place on the record the article in the Arizona Mirror from July 7, 2022, when Mr. Baranovich laid out his position entitled, "Baranovich Lagging in the Polls Begs Ducey to Declare an Invasion to Militarize the Border."
Without objection.
Thank you. I know Mr. Jadwat was asked some questions about whether there was a contradiction between the clear language of the Constitution and the Supreme Court's holdings, saying that the federal government has sole authority over issues regarding immigration and admission to this country. And he was asked whether the use of the National Guard in California to address smuggling and distribution of fentanyl in that state somehow was contradictory there. Now, I know that we don't have before us the exact terms there, but is there a distinction, Mr. Jadwat, between the federal supremacy on issues of border security and immigration and the state's ability to enforce criminal laws within their own state that do not directly address border security?
Yes, there is. The states obviously have, criminal laws of their own and the ability to enforce them.
So if someone brings fentanyl into the country and then seeks to distribute it in California, California would be justified in trying to stop that distribution in its state?
Yeah, I assume that's illegal under California law, yeah.
You've been asked a lot of questions about the meaning of invasion, and many of those questions have kind of run roughshod over the constitutional meaning, the constitutional history. Can you just lay out one more time what the constitutional meaning is and the historical context for the invasion clause?
Sure. And again, I mean, the reference to invasion that folks are relying on here is actually, you know, an exception to the rule, right? Actual invasion. The main point of the compact clause is that states can't engage in war or do any of that other long litany of things, that that's a federal responsibility, right? And so the exception, in order for the clause itself to make sense, can't be so broad that it swallows the rule. The theory that they're putting forward here of an unreviewable ability of any governor to point to pollution, to point to gangs, to point to people coming in and say, voila, invasion, I get to wage war, would completely undermine the main purpose of the compact clause. And with respect to Mr. Brnovich, when Madison talked about pirates, he wasn't purporting to define what an invasion was at all, much less an invasion under that clause of the Constitution. When Madison did talk about the invasion clause and immigration, he said that immigration was not an invasion. Well, he said that invasions that require the war power and immigration are distinct things. And so there's no contemporary support for their position at the time, at the founding. The text obviously doesn't support what they're saying, and the implications of their argument, which again, nobody has purported to address on this panel, are really breathtaking and, you know, would really undermine our entire constitutional system.
I appreciate that, and if we do turn back to the actual clause in the Constitution, it talks about the obligation of the federal government, not the administration. And so our continuing concern is that we're in a situation here where our colleagues are blocking legislation that would allow the federal government to address issues of border security, and they're blocking funding that would allow the administration to address border security, and then placing us in this position where they then flip it and try to argue. I do want to thank Representative Ms. McClintock for pushing back on this deeply disturbing idea that the federal government is bound by the determination of individual states in interpretation of the Constitution. Again, that would completely upend our constitutional order. I see my time has expired, so I would yield back.
I thank the ranking member, and I now recognize the gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. I yield to the gentleman from Texas presiding, Mr. Roy.
I thank the gentleman. Question for the panel. I mean, what amount of death and destruction among the people of Texas or any other state is sufficient to say the state should take action under the law? Like, how much death should Texas take? How many Texans should die every day? Again, fentanyl, we've got 75,000 across the country, whatever the thousands are in Texas. How many of those should die every year before the state of Texas does something about it? Okay, put aside the fentanyl because, oh, that's all ports of entry problem. That's all bogus. We could have that debate separately. There are other issues with that. Border Patrol is distracted. But I would just say, Mr. Webster, as someone who's a Texan, what is your answer to that question, right? Before Texas takes action, the governor is taking action, in the absence of action from the President of the United States, do you think there is a level of death, destruction, danger to the people of Texas that he should tolerate in the absence of the federal government doing his job?
No, there's no, I think the governor has a duty and obligation to protect the citizens of Texas, and when he sees harms coming upon Texas, he has an obligation to act, and has.
Yeah, Mr. Jabwat, I mean, is there a level of danger to the people of Texas that you believe would say the governor has a right to go defend itself, as in a family whose house is being invaded at night, has people coming in and trying to attack one's family? Does the governor not have some duty to be able to defend? For example, if cartels came across the Rio Grande, guns a-blazing, not wearing a uniform of Mexico, but just a hodgepodge of individuals in various articles of clothing came across guns a-blazing into Laredo and said, could the governor repel that with DPS? Not the National Guard. Could the governor say, you guys, boys, shoot back?
Are you asking whether the Texas has the police power to address armed people running around in the streets and shooting
coming
guns?
across the Rio Grande, they're armed. Can the governor repel
Once
that?
they're in the state of Texas, if they're violating Texas's criminal laws, of course the governor has the ability.
So if they're violating Texas's criminal laws, apparently the governor can do something about it. That's an interesting observation. I think it's an important one. Because of course the governor of Texas can deal with it if the laws of Texas are being violated, and the people that the governor is supposed to represent is entitled to defend them. I would ask another question, which is, would the states, in this case, Texas or Arizona, we have two representatives from those two states here, past and present, would those states have entered the union had the theory being promulgated by my colleagues on the left been openly put forward and said that we, the federal government, will not enforce immigration laws to the tune of 900,000 releases last year, plus hundreds of thousands of more through parole, plus hundreds of thousands more gotaways, overwhelming the jails that we said, oh, sure, just use the jails, go do it, go arrest people that are bad actors, filling the jails, filling the hospitals, filling the schools. If the federal government had said, here's the deal, Arizona, here's the deal, Texas, can you, either of you gentlemen, imagine a scenario in which Arizona or Texas would have joined the union? Texas in 1845, and forgive me for not knowing the year from Arizona. You, Mr. Brnovich, or Mr. Biggs would know. Mr. Webster, could you answer that question? Would they have joined the union under that theory?
I mean, if I was there, I can't imagine taking on a situation where I would be defenseless. And what you're proposing is a situation where Texas would be defenseless.
Correct. Mr. Brnovich, can you imagine that scenario?
Well, I will just go as we talk about first principles and documents, and Mr. Webster just spoke. So let me quote from Daniel Webster's 1806 dictionary, the first American dictionary. At that time, the word invaded was defined to mean enter or seize in a hostile manner. Webster's 1828 dictionary, furthermore, went to describe invasion to include attack, assault, assail, to attack or infringe or encroach on and violate. And if you look, with all due respect to my colleague at the end of the table, he had mentioned James Madison. Look, I mean, during the constitutional debates, if you read Federalist 43, you read the original Federalist Papers, the states entered this union. The states created the federal government with an expectation that the president, the commander-in-chief, would exercise authority when it came to, you know, the commander-in-chief authority in defending the states. However, that's why if you have to read this all together, Article 1, Section 10, and Article 4, the states have this inherent right to defend themselves when the federal government will not do its job. And so it's not an offensive or a proactive power, so to speak. It is defensive in nature, that every state has the ability to defend itself and its citizens from either a state or non-state hostile actors.
Well, I agree, and I appreciate the comments from the gentleman from Arizona, the Attorney General. I appreciate that. And with that, I'm going to recognize the Chairman of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Webster, what if we just called a timeout? What if we just said no more? We're on pace to get to 12 million. What if we just said time out? No more migrants can come into the country. Wouldn't that make some sense?
That would make absolute sense and would be what Congress intended when it passed the laws we have on the books right now that gave the president the power to stop this.
Mr. Attorney General Brnovich, would you say the same? Would you say call a timeout now? It's gotten to we're on pace in the Biden administration to reach 12 million, the equivalent of the entire population of Ohio. Maybe it's time to say timeout. 3 years and 10 days of this is enough. Just call timeout. And I would argue the way we do that in a legislative body, the way our Constitution works is we have power of the purse. So we say no money can be used to process or release into the country any new migrant. How about this for Texas and for Arizona and for New Mexico? No money can be used to take down any border structures that those states have put up to enforce the law. What if we just said you can't spend money to tear down the fence you're putting up, you can't spend money to process and release into the country, new migrants come in and just say time out, it's gotten so bad, let's just call a halt to it now and have an election and see what the American people say.
Mr. Chairman, obviously the states have become very frustrated with the inability of the federal government to do its job. And as I have mentioned previously, Congress does have remedies. I mean, Congress could impeach officials for failing to
Well, they're doing that
protect
right
our.
now, yeah.
That's what I've heard. Congratulations! I'm glad it's finally happening. But you have. You also have the ability, I believe, to cut off funding, as you mentioned, to the federal government to stop them from interfering with Texas' ability to.
I'm not trying to cut you off because you're agreeing with me, but I want to recognize, I told him I'd give him 4 minutes, I'm giving him 3:20, so I'll give my time to the gentleman from Arizona.
I thank the chairman. So my extreme Marxist colleague, who is a mindless follower of Joe Biden, raised the specter of insurrection and lawlessness. And the lawlessness that she was talking about is January 6th. How about the stinking lawlessness at the border every day? Title VIII is violated every day by this administration.
Can I raise a point of order?
The Title VIII.
Just hold on the time. The gentlelady has a point of order.
Can we ask members of the committee not to cast aspersions upon members of the committee?
We had aspersions cast upon us by your member, ma'am.
Yeah, I mean, my observation is that extreme MAGA is used on a daily basis by the second, and so
Repeatedly.
saying extreme Marxist is fair game. You'll have the gentleman from Arizona continue.
Thank you. So the lawlessness that you see is coming across the border every day, failure by this administration to enforce the law. So let's get back to this. And I would just want to say one other thing. This is relative to what we've heard from one of our panelists. He's conflating, again, immigration law with border security. Now, there's a reason that you have 3 provisions in the Constitution that kind of address this. Article 1, Section 10, twice. Article 4, Section 4. One is dealing with invasion, and that is the security and safety of the nation, of the sovereign states. The sovereign states that actually created this federal government. The article in Section 10 that Mr. Brnovich brought forward with the authority under Article 1, Section 10, the state may defend itself when it has been actually invaded. Also, the invasion clause, Article 4, Section 4, that's what we've been talking about. But the import-export clause, that's one I want to get to. Article 1, Section 10. A very unique understanding, but it gets at the heart of this. Expand, please, Mr. Brnovich, in about 30 seconds, your idea of the sovereign authority that rests with a state under the Import-Export Clause, Article 1, Section 10.
Thank you, Mr. Biggs, for bringing up this very, very important point we haven't had a chance to discuss today. The Import-Export Clause provides that states do have the ability to control what kind of goods are coming into their states. And even if you accept the premise of what other members of this committee have talked about as far as states not being able to enforce immigration law, that's generally true. However, states can control what is coming into their states. And so, for example, in Arizona, we have 10 ports of entry. I believe in Texas, there's 28 ports of entry. If the Biden administration wants to create an 11th or 12th or 29th or 30th port of entry, then Congress and the federal government can do that. But the states, at the same time, have the ability to force and channel all people, all goods, and commerce into those lawful ports of entry. So I believe there's a very strong constitutional argument, putting aside some of the other language, but even under the Import-Export Clause, that states have the ability to force anyone coming into Texas or Arizona or California, any other border state, into those lawful ports of entry.
And so we get to the point, it is also, again, just as we were discussing about Article 4, Section 4, the invasion clause, in this clause, this is actually even more explicit. The authority rests with the sovereign state. It does not devolve to the federal government. Why would you allow the federal government then to say you can't have control of import-export, or you can't control and determine what an invasion is, when the sovereign state, and don't forget that the founders intended to recognize the sovereignty of the states to govern themselves. If you're going to turn the definition of invasion over to the federal government, who is violating the invasion clause, it just stands logic on its head. Yield back. Thank you.
Thank you, gentleman from Arizona. I assume there are no more witnesses from my colleagues on the other side of the aisle. So with that, this will conclude today's hearing. We thank the witnesses. Do we have? We don't have any more witnesses, right? Okay. That concludes today's hearing. We thank the witnesses for appearing before the committee today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, this hearing is adjourned.